live.
All right. I'm waiting for it to show that it's actually live on the YouTube channel. And I know there's a couple of second delays, so all right, we're good. So we're active now, so I'll go ahead and introduce. This is Damian Flynn with Coast Hydro Beams Consulting. The intellectual property rights, Linux intellectual property rights webinar is starting now. It is being recorded, so if for some reason you're not able to sit through the whole thing, you can catch it back on the Carlos Villamar's YouTube channel here in a little bit, and it's the same channel you're sitting at, the same link. I just wanted to do a brief intro. A couple of weeks ago, we had in one of the aquaponics groups that we both visit in, there were some questions about some patents in the aquaponics community. So we decided to get together and put this this webinar together to address some of those. And you know, Carlos, he was very thoughtful in offering his time to go ahead and do this for us. So I'm going to turn it over to him in just a minute, but I did want to real quickly go over our sponsors for this. We do have a couple sponsors that help make this come true. Since we're not selling anything, it made sense to go ahead and get some sponsors to help us out here. Obviously, you know, my company is helping to sponsor this. Michael Neal is also a good friend of mine, and he's a bit of a philanthropist. If you're looking at the webinar here, you'll see the link on the page. I would suggest going here and just checking out his website, michaelneal.com. And then 360 Training, they do a lot of training for you know, for different job placements, insurance, hazmat, all kind of different trainings. And you can go directly to beams.com/IP-webinar and see all these links and check them out. So right now I'm going to go ahead and turn this over to Carlos in just a minute. And I was going to introduce him, but I'm going to actually let him introduce himself, because if I do it, I'm probably going to overfluff him, and he's warned me against this. You know, the attorney speaks, so I'm going to let him introduce himself and let him take it over from here. There, Carlos?
Yeah, I'm here. Did you transfer over?
I did.
Hey guys, this is Carlos Villamor. I'm a patent attorney. A lot of you guys might not know what a patent attorney is, but in the United States, a patent attorney is an engineer first, and then they go to law school. And after they finish law school and pass the bar, they become patent attorneys. I was a practicing engineer for almost a decade. I worked at General Dynamics and also Hughes Aircraft, and became a patent attorney because Hughes Aircraft back in '94 was laying off. They laid off about 40,000 out of 80,000 engineers. And I was looking for a plan B. And this is my plan B, being a patent attorney, and it's quickly become a plan A. So I am a real engineer. I'm highly technical. My background's electrical engineering, artificial intelligence. I've done lots of work as a patent attorney covering all sorts of technologies. That's the interesting thing about being a patent attorney, is that you become a jack of all trades and a master of none. I do specialize in artificial intelligence and computer architectures, but I've covered technologies from everything from talking dolls to fighter aircraft. I'm going to go ahead now and start the seminar. I'm going to share my screen, and basically you should be seeing the screen right now. These are some of the things I'll be talking about today. Some of the things I'll be talking about today is listed in the webinar, is the differences between a patent and a patent application, important parts of a patent, important dates, what a patent protects, the claim of a patent, basic infringement, basic novelty, basic design around, and some online patent resources. Now, each one of these topics could actually be its own 1-hour lecture, so we're going to cover these pretty quickly, but my understanding is we can take some questions if time permits. So I'll go ahead and start out with the differences between a patent and a patent application. I didn't want to use any of the patents that were in dispute right now in the various forums, because I don't want to get involved in any issues with respect to you know, any legal issues with respect to the pending patent applications or patents that were discussed in the forums. So what I'm going to do is I'm going to cover my own patent application. This application is currently pending under the Patent Office. We've gotten an office action, which means the Patent Office has rejected all of my claims. So now I got to go back with the patent examiner and explain the differences between my invention and the prior art to try to get a patent allowed. So I'm going to switch over now to the patent application that I filed. This is actually a Google patents search that I did. I searched for Villamor and aquaponics, and I found my patent application. Google Patents is actually an awesome resource for finding patents and patent applications. And as you can see, it has the abstract, which talks about the system itself. And then it goes on into other aspects of the invention, including the drawings, which you see down here in the center. And then it starts getting into the text of the patent application. Now, the difference between a patent and a patent application is pretty straightforward. Like if you look at this Google Patents page, you can see this download PDF page. That gives you an actual PDF copy of the papers that were filed in the patent office. I've already downloaded them, so I'm going to switch over now to the actual patent application. And you can see here, it says patent application publication, and it has publication number. You notice this number has a year and a serial number after it. This is how you can tell that this is a patent application and not an issued patent. And there's a difference. A patent application is an application that's pending, whereas an issued patent is a patent that's actually been granted. And the difference is whether, with a granted patent, you can actually go after infringers, people that are violating the claims of your patent. And I will be covering those components shortly. So the nice thing about Google Patents, they also list all the references that were cited against this patent case. And I pulled up one of the older patent references, and it's called a fish farm and hydroponic greenhouse. You can tell that let's see, legal status, this patent has expired. What that means is this patent, for whatever reason, is not in force. This is important because you cannot be sued on a patent that is expired. Okay, and patents can expire for various reasons, including not paying issue fees and things like that. So now we go to the PDF of this patent. This is Inslee et al. And when you look at the patent, you can find various information, the title of the patent, the first name, the last name of the first name inventor. Et al. Means that there's multiple people on this patent. It has the date of the patent. That's the date that the patent was granted in 1991. And then it's got the patent number. So you can see the difference between a patent application is basically you just have to read the top portion of the application or the patent in question. Okay, so that's the difference between a patent, or at least recognizing the difference between a patent and a patent application. By the way, there is a legal disclaimer here. All of this information is not considered legal advice. This is only for informational purposes. If you need help with patent law, you should hire a patent attorney. Anyways, now we're going to cover the important parts of a patent. We can go to the application because patent applications become patents. And there's three key components of a patent application. There's the description, there's the drawings, and finally, there's the claims. So those three components make up a patent application. And for example, if we go here and click on these drawings, this is my figure 1, which shows my aquaponics solar greenhouse with the grow beds arranged around a common fish tank. Each fish tank has its own bell siphon as well as its own geyser pump. This system is N-way redundant. Every grow bed runs on its own. The other thing that's distinguishing over the prior art is this system runs completely from air. There are no water pumps in this system. And also this system, besides the energy to run the air pumps, requires no heating or cooling because it's inside of a Chinese solar greenhouse. So here's another view of figure 1. So anyways, you have the drawings that describe your patent application in enough detail that somebody can make and use the invention without undue experimentation. So the parts that make up the patent are the drawings, the description of the drawings, and then finally the claims. So those are 3 important parts of a patent or patent application. Now, the difference between a patent and a patent application with respect to the claims is these were the claims that I was hoping to get over the prior art. So when I filed this application, this is what I thought made my system novel. However, once the case actually gets examined and prior art gets cited, I may need to amend these claims to get around the prior art that was cited against these claims. So an important takeaway from this is that the claims are what define what is being protected by the application. Now, I've had a lot of people post on forums saying, everything they're doing in the application is well known. Well, what they say in the description, the drawings, does not really matter as much as what they're actually claiming. Now, another issue that came up with some people was, well, I'm going to get sued over using a system in my backyard. Well, for example, my patent application is free for personal, educational, and non-commercial use. I don't want to go after people that are building things in their backyard and that are growing food. In fact, I want to encourage that. However, what I don't want is a large corporation copying the idea and then mass producing it and selling it in the open market. And that's why I filed for a patent application to protect this potential invention. So let's see. The important parts of the patent, as I mentioned, are the description, the drawings, and the claims. Now let's cover the important dates of a patent. Dates are important because that determines when the prior art, what is prior art. Basically, when you file a patent application, for example, let's take a look at my patent application. It was filed February 27th, 2015. However, before I filed this case in February 27th, I had filed a provisional application, which is another type of patent application that still gets you patent pending status. This provisional application was filed February 28th, 2014. What that means is that the patent office, in order to invalidate the claims of my patent, they have to find patents, publications, or any public disclosures or white papers, etc., before this critical date of February 28th, 2014. So, on the forums, a lot of people were saying things like, yeah, how can, this can't be patented. People are doing this now. Well, it doesn't matter what people are doing now. What matters for this application is what were people doing on February 28th, 2014. So the filing date, and more importantly, the related application date, will help you find the earliest priority date for prior art. And what that means is that patent examiners have to cite references, white papers, articles, etc., that were published or made available to the public before February 28th, 2014, in order to reject the claims that I have in this patent application. So, so that's a patent application. So what about an actual patent? Well, a patent has a date that the patent was issued. That is a very important date because what it means is after this patent issued, anybody that was committing infringement after that date could be liable for the infringement of the claims of this patent. Now, people get confused with patents because I've seen a lot of people saying, well, that person never should have gotten a patent. Well, the thing about the way this works is you file an application, you go back and forth with the patent office, they cite prior art, you get the patent allowed, and once the patent is allowed, it has a presumption of validity. And what that means is that if this patent gets asserted against somebody, you have to show, basically you have to beat the priority date of this application if you want to say that there's prior art. So for example, this application was filed May 19th, 1988. This is a fish farm and hydroponic greenhouse. So if this patent were valid and still asserted against you, and you were trying to invalidate it based on prior art, you would need to beat this May 19th, 1998 date, assuming, of course, that this case doesn't have any continuation, isn't based on a previous case. And it looks like this case does not have any previous cases. So basically, this is the prior art date for this particular case. So, let's go back here and just make sure I'm covering. So those are the important dates of the patent. You want to find the actual filing date, and you want to find any possible priority dates to determine the dates of the prior art that you would need to assert against that patent in order to argue that the patent is not valid. That's because, like I mentioned before, a patent is presumed valid until it gets asserted, and once it gets asserted, the party that the patent claims are asserted against can go ahead and submit prior art or make arguments to try to invalidate the patent based on the prior art date. Okay, what does a patent protect? Well, the patent protects what is claimed by the patent. So let's assume that this patent was still alive. Like we noticed over here that this is an expired patent. Now, the fact that a patent is expired is important because the way the patent system works is you get a patent and you get to have a monopoly on your idea, which allows you to keep others from doing what you invented for the term of the patent. But once the patent term is over, which is 20 years from the earliest priority date, the patent enters the public domain. So this was filed in 1988. And let's see. Yeah, so this patent, if roughly probably expired around 20 years from the earliest filing date, which is around 2008. That patent should have entered the public domain. I haven't checked it specifically, but that's what it looks like. So what that means is that everything that is disclosed in this patent application that is now expired, anybody can do. This has entered the public domain. Anybody can practice these techniques. And what that means is that you can't have a patent asserted against you if it has expired. Now, there's other ways that patents can expire. For example, you can fail to pay your fees, which can cause the patent to be abandoned. But at the end of the day, you always want to make sure of the legal status of the patent to make sure that the patent can still be asserted against you. So, back to what it protects. The claim is the name of the game. One patent application, which is a drawing and description, can generate numerous claims. And each set of claims can become a new patent. A good way to think about this is think of a car. A car may have anti-lock brakes. It may have a GPS system. It may have other systems within the system that we call a car. Well, each one of those systems could become a separate patent application. So what that means is a separate patent. So you could have a patent application that describes the car, and maybe the first set of claims is directed just to the anti-lock brake system or just to the GPS system. The bottom line is that you can, in that system that I described earlier that's made of anti-lock brakes, GPS, and maybe some engine control systems, you can write claims for each of those separate inventions and end up getting patents covering each of those separate inventions. Now, the only difference between patents patents that are based on other patents are the claims. The description and the drawings will be identical. The difference will be what is claimed. So for example, let's take a look at this patent that is now in the public domain. And let's look at what you have to do to infringe this patent. By infringe, I mean what you have to do to violate the claim of this patent. Now, as I mentioned before, this patent is expired. So these claims, in a sense, are meaningless because everything that was done in this patent is now in the public domain. However, let's assume that we go back in time to the year 2000 and this patent is still in force. In order to infringe this patent, you have to perform every step in this claim 1. Now, the way the claims are written is the broadest claim is first, and then there's claims that depend on the broadest claim, which further limit the broadest claim. So let's look at the broadest claim first. A fish assembly comprising. Okay. A fish tank adapted for containing water and fish therein. Okay, so you have a fish tank. One or more airlines positioned at the bottom of the fish tank, wherein the one or more airlines are adapted for receiving air and for releasing air in a column of rising bubbles. Okay, so far this is covering aeration of a fish tank. Now, who the heck hasn't aerated their fish tank? Pretty much everybody. So right now there's probably tons of prior art covering that stuff. So now there's another element, and again, you have to do everything. You have to have the fish tank, you have to have the air stones, and now you need a biofilter that is characterized by a surface adapted for supporting microorganisms, wherein the surface is at least partly defined by a plurality of vertical channels, wherein the biofilter is positioned in the fish tank. So when the tank is filled with water, the biofilter will be submerged and the vertical channels will be above one or more airlines. So this claim covers the concept of having a suspended biofilter over the fish tank with the airlines underneath the fish tank. And let's take a look at the drawings and see if we can figure out what the heck they're talking about. And I won't spend too much time on this, but you could go through the drawings and try to figure out what the heck it is they're talking about. But these look like vertical columns, and it looks like these are air stones. So it looks like the air comes up here and flows through these vertical columns, and those vertical columns, to infringe the claim, one or more airlines position a biofilter characterized by a surface adapted for supporting microorganisms, wherein the surface is at least partly defined by plurality. Okay, so those vertical columns have to have a surface for having bacteria. So this covers a specific configuration that we saw in this drawing, that has these vertical columns with air stones underneath. And these vertical columns will become filtration devices. So here we've shown how the claims and the drawings are related. And unless you're doing what is being claimed here, by this claim, unless you're doing every single step that's defined by this claim, you will not be infringing claim 1 of this patent if it were still in force. So now there's claim 2. If you also do all of claim 1 plus all of claim 2, now you're infringing claims 1 and claim 2. Now, claim 2 further requires the dimensions of the fish tank, the dimensions of the position of one or more air stone lines are such that when the tank is filled with water, the column of air bubbles rising from one or more air stones will produce in the water a current which agitates substantially all water in the fish tank. Okay, so unless you're also doing that, you would not violate claim 2. You have to do everything in claim 1 plus everything in claim 2. For claim 3, you have to do everything in claims 1 and 2 plus everything in claim 3, because claim 3 depends from claim 2. Finally, claim 4 depends from claim 3. And in order to violate claim 4, you have to do everything in claim 1, everything in claim 2, everything in claim 3, and everything in claim 4. So under infringement analysis, you can be sued for just violating claim 1, for 1 and 2, 1, 2, and 3, 1, 2, and 3, and 4, depending on whether you're doing everything that is being claimed. So that is why the claim is the name of the game, because the claim defines what you have to do in order to infringe the claims of the patent that is being asserted against you. So now let's look at some basic infringement analysis, and of course it's tied to the claim as the name of the game, because at the end of the day, you infringe a claim, you don't infringe a patent. There's the term patent infringement, but at the end of the day, you have, if you're asserting infringement against somebody, you have to say that what they're doing violates one or more of the claims of your issued patent. Okay, so, if we were doing basic infringement analysis, it falls really out of the analysis that I did earlier. In order to infringe the claims of this patent, in order to infringe claim 1, you have to do every step in the claim. So you have to have the fish tank, the air lines, and the biofilter, which is made of vertical columns with the air stones underneath the columns. Okay, so unless you're doing that, you don't have to worry about this patent. Well, you don't have to worry about this patent also because it's no longer an enforceable patent. It's expired. But let's go back to my patent and my claims to give you an idea of what you would need to do to infringe the claims of this patent application. Now, right now, these claims have not issued, so technically these claims are probably going to change before the patent actually issues. I'm set to talk to the examiner shortly to discuss my application and to try to get around the prior art that was cited. This requires an aquaponics and greenhouse system. So, you're going to require a greenhouse plus an aquaponics system. Well, let's look at the elements of this aquaponics and greenhouse system. You're going to need a solar greenhouse, insulated on the north, east, and west sides, and with glazing on the south side at an angle to maximize winter sunlight and housing. So the solar greenhouse has to be configured as what's known as a solar greenhouse, which maximizes the southern exposure through glazing and includes insulated walls on the east, west, and other sides. And it's going to be housing, inside of the greenhouse, you're going to need a fish tank. And you're going to need a plurality of grow beds coupled to the fish tank. What a plurality means, more than one. Okay, so you need more than one grow bed coupled to the fish tank, and this is probably a good figure if it wasn't lopsided. But you can see I have the fish tank, and I have multiple grow beds, 1, 2, 3, 4, 5, 6 grow beds in this case, coupled to the fish tank through these geyser pumps and through these other mechanisms. So let's go back to the claim. So now you need the plurality of grow beds, and then the grow beds each including, so that means every single grow bed has to have a geyser pump. And a geyser pump is an airlift that's powered by air. It's a type of airlift. And it's gonna have to pump it's gonna be powered by an air pump to pump water from the fish tank to the grow beds and aerate the water of the fish tank. Okay, and each of the grow beds are also going to include a bell siphon to drain water from the grow bed back into the fish tank. So again, I'm covering the concept of each grow bed having its own air supply. This system is 100% air powered, by the way, so it doesn't require any water pumps. and so far the prior art that's been cited requires water pumps. Now this is a sort of sideways look, but here's a picture of the geyser pump that each grow bed has, and it's basically a large tube with an air pump. The air fills in this tube and then pumps water out to the grow bed. And then there's the bell siphon, which is this is an external bell siphon design. The water fills up in the bell siphon, and eventually it overflows the standpipe, which creates a vacuum which drains the grow bed. So if this claim were allowed in a patent, you would have to do everything here in order to violate this claim. And again, that's basic infringement analysis, is you have to look at the claims and you have to figure out whether you're doing everything that's within the claims in order to determine if you're violating the claims of that patent. And again, that's why the claim is the name of the game in patents. Now, if we look at novelty analysis, okay, so there's infringement analysis is what you're doing violating the claims of a patent? Novelty analysis, on the other hand, determines, are the claims that are being asserted against you novel? Okay, and we covered the important dates of a patent earlier, right? So novelty is based on the priority date. So let's go back to my application. If you want to invalidate the claims of this patent application, you have to find prior art before February 28th, 2014. So let's say I was asserting this patent against you. And again, my patents in aquaponics are free for personal, educational, and non-commercial use. So let's say a large corporation decided to copy my system that works completely from air and uses exclusively geyser pumps. Let's say I was going after them. Basically, what they would have to do is they would have to find prior art with respect to novelty. In other words, before February 28th, 2014, there was prior art that either did exactly what you're claiming. So in other words, the prior art would have to show a solar greenhouse, a fish tank, a plurality of grow beds where each grow bed includes a geyser pump, and each grow bed has a bell siphon. So the prior art that you would have to find to invalidate this claim would have to be before February 28th, 2014. And I saw a lot of people on the forums, making the mistake of saying, things like, well, this was done on such and such a date, without really paying attention to the important dates, the dates that you have to beat. Now, as far as the patent that was being discussed in the forums, I don't even remember the number of it anymore, but a lot of people were concerned, they're going to start coming after me. Well, as I said before, I wouldn't go after people that are using it for educational, personal, or commercial purposes, or non-commercial purposes. And I suspect the person that got that other patent probably would probably, not also go after individuals. Now, that doesn't mean that you can't. In other words, when you have a granted patent, you can go after anybody that's infringing the patent, whether it's for educational purposes, non-commercial or commercial or personal use. But I'd be very surprised if the people that were, the applicants for that other patent are really considering going after Joe Blow in his backyard building a system. Just like, I don't care. You want to build my system in your backyard, more power to you. you want to take it and start commercializing it and selling it, well, then I'm going to have a problem with that. And that's the reason that I filed for a patent application. So basic novelty analysis, again, is really tied to the dates of the patent, the important dates of the patent, and really, you know, finding something that was in the public domain before that priority date. Now, what can be used as prior art in a patent can be anything from patents, applications, and here's a good example. You know, here's my patent application. The examiner cited 15 patent citations. So these are all the patents that were cited that are relevant to my claimed invention. Fish farm, thoroughly efficient greenhouse, system for removing pollutants, greenhouse roof glazing system, et cetera, et cetera, et cetera. So these are the patents and applications that were cited against me. Now, based on what I taught you, you can tell which are applications and which are patents. That's a patent. It's got the shorter number. Here's an application. Here's a patent. Here's an application, 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 patent, application, application, application. So these are patents and patent applications that were cited in my case. And actually having a lot of citations in your case is a good thing, because the more things that are cited, the more things that the examiner has considered. So when the patent is issued, it's very hard for a third party to come in and say, oh yeah, you know, they shouldn't have allowed it over this greenhouse glazing system, because once a patent gets issued, it has a presumption of validity. And once the examiner has considered the references and still allowed the patent, you have to go back and argue that the examiner made a mistake, and the level of you know, your standard for arguing becomes much higher, from like preponderance of the evidence to clear and convincing evidence. You know, so once a patent has a presumption of validity, it's much harder to argue that the examiner made a mistake, and that, you know, the patent shouldn't be allowed over the references that were cited. So having lots of cited references is a good thing. It also tells me that the examiner is doing a good job. You know, the fact that lots of references have been cited means that the examiner has fully considered my invention and has found as much possible prior art as possible in order to try to invalidate my claims. You notice all of the years are before 14, 12, 11, 10, 10, 8, 8, 8, 6, 6, 5, 98, 97, 91, 1988. And that's because she has to beat the priority date that I have, which is this February 28th, 2014. Okay, so she cited some, as I was mentioning before, with respect to prior art, there's patents and published applications. There's also non-patent citations. So, you know, besides you know, having you know, things that are citations that are based on patents and applications, you know, here's a citation from 2012 called Sustainability at Worcester, received from sustainability.com. You know, here's the link to that publication. So this was also cited as a non-patent prior art, and I'm going to that. And here it is. You know, here's a post from 2012, you know, before my 2014 date, that the examiner has included in my application. You know, that we could go back and look how she applied it, but, you know, it's relevant, I guess, to, you know, she thought it was relevant to my system, and that's why she cited it. So you have the patent citations, which includes patents and publications, and you have the non-patent citations, which are not patents and publications. And then the interesting thing that Google does is they have similar documents. You know, this is a Google thing. In fact, a nice feature of Google, which I'll come over here if you're having a patent asserted against you, is let's find a live patent. Let me go back to mine.
Hey, Carlos,
ahead.
real quick, while you're looking for that, we had a question here. Paul asked, so on a particular patent, if you do not utilize all the components outlined in Claim 1, you are not technically in violation. Is that correct?
That is correct. And since Claim 1, now remember there's multiple claims in a patent, so you have to look at every claim. But let's go back to this issued patent, okay? So this patent had, we already looked at, over here is probably a better view. So we already looked at Claim 1, right? You have to do everything in Claim 1 to violate Claim 1. You have to do everything in 1 and 2 to violate Claim 2, 1, 2, and 3 for 3, etc. But see, there's more than one claim. This is a fish tank assembly, okay? Now you have an indoor fish farm. Now, in order to violate this claim, you have to do everything that now is in this claim. A fish tank, an enclosure. So it looks like, you have an enclosure, a fish tank assembly disposed within the enclosure. A fish tank, and now you've got the same claims of this, this is the same stuff inside of here. So in order to violate Claim 5, you have to do what was in Claim 1, which is this stuff right here. Plus you have to add an enclosure and these other elements as well. I hope that answers Paul's question. And let's see, where was I? Basic novelty analysis. So anyways, I was mentioning that numerous things get cited in the patent application, and Google has a feature that and I'm going to pick a fairly recent patent. You can see the numbers are small, which means it's a old patent. The patents right now are in the 900 series. So let's take a look at this 891501. This is a solar greenhouse patent. Okay, so this one, look at the legal status. It's active. It expires in 2032. So this patent is going to be alive for probably way after this technology is even relevant. Okay, so this is a live patent, and this covers a solar greenhouse. Okay, and if we look at the drawings, you can see, the structures that they were trying to go after. These are the different components of the greenhouse. And you can see they describe in detail all the various parts, etc. So anyways, this is a live patent. Okay, this is live, and it doesn't expire till 2032, which, by the way, in technology is a lifetime. This stuff will not be relevant in the next, who knows, maybe 5-10 years. It may be no longer relevant. So anyways, there was 14 patent citations. There was, here's a similar documents. And I thought there was a find prior art button, and I can't seem to find that anymore. Oh yeah, here it is, find prior art, a feature of Google patents. So let's say this patent was being asserted against you, and in order to violate this patent, you need to violate everything in the claims. A solar greenhouse comprising a structure defining enclosure, a structure having a property of light transmissive panels, okay, glazing. A plurality of rotatable positional louvers disposed adjacent to at least one of the transmissive panels. So you need rotatable louvers. They're having a reflective surface, so you can see that you might have a solar greenhouse and say, oh my God, I'm afraid of this patent. But you don't have to be afraid until you look at the claims and you determine whether you're doing everything in the claim. Okay, so these claims are being asserted against you, and remember, they've got a claim 1, a claim 2 that depends from 1, a 3 that depends from 1, a 4 depend. All of these claims depend from claim 1. So to violate 2, you need 1 plus 2. To violate 3, you need 1 plus 3. To violate 4, you need 1 plus 4. To violate 5, you need 1 plus 5. And to violate 6, you need 1 plus 6. But you're not done yet. There's another claim here, a solar greenhouse comprising, and it's a different claim. Now you have to go and do everything that is in that claim. And this one has some more stuff about a circulation system coupled to, you know. So anyways, you have to do everything here. And again, with the dependent claims, to violate claim 8, you have to do 7 plus 8, 9 plus 7, 10 plus 7, 11 plus 7, 12 plus 7, 13 plus 7, and then 14 is actually 7 plus 13 plus 14. So when you get hit with patent infringement, all they have to assert is that you violate one or more claims. You may only violate claim 1, or you may violate 1 and 2, you know, any combination. But in order to sue somebody for infringement, they have to infringe one or more claims of a valid enforceable patent. So let's see if that covered basic novelty analysis. Yes, you know, so in order to get out of that claim, you have to find prior art before the critical date of this case, and here's the priority date right here. You have to find prior art before May 19th, 1998. I'm sorry, 1988. So that's how the critical date, the infringement, the novelty analysis are all tied together based on these very important dates of a patent that we covered. So how do you design around a patent? Now, again, every one of these topics could literally cover easily an hour or more in and of itself. But when you're doing basic design analysis, design around analysis, as I mentioned before, in order to infringe a claim, you have to be doing everything in the claim. Okay, so for example, let's say you built a solar greenhouse that was identical to this. You're doing every single thing in the claim. You come to me and you say, Carlos, I'm literally infringing this claim. I built a system that's an exact copy of what they're doing. Well, if you want to design around it, you have to look at the components and see if you can substantially substitute something in there for something else, so that you can say, you know, I do not have a drive system for positioning the plurality of louvers in various positions with the surfaces selectly positioned for solar collection. Okay, because you have to do every single thing in the claim, you can design around a claim by not doing something in the claim. I think a concrete example would be most helpful. I used to do design arounds for a major corporation that would basically, they would sell stuff, you know, for Sharper Image or whatever, these sort of stores. And they would see a good idea and they would just copy it and start selling it. And sure enough, they would get hit with an infringement claim from whoever actually had the patent on that idea. And I would go to them and I'd say, can you tell me what's different between your invention and the patent claims? And they would say nothing. We're doing exactly what's being claimed. So now, you know, you're infringing, and you know, let's assume that the patent is valid and novel. So now the next question is, you know, they would say, Carlos, how can we design around this patent? And what I would do is I would study the patent, and I would, being an engineer, I would think of clever ways of getting rid of some of the elements within the patent. A concrete example, there was a patent on one of these LED lights that looks like a natural light. It looks like a candle, and you've probably seen them at dollar stores and stuff. They're basically these LED candles. You know, something like you know, something like these that you see in these images here. And there was a patent that was being infringed where these candles looked natural. You know, they wouldn't keep a constant intensity. They looked like they were moving. Well, you know, the infringer was copying this exactly. You know, the way the claim was written for the LED candle, it required a register that stored a random number, a pseudo-random number. Now, a pseudo-random number is a number, a random number that can be generated by a computer. So what you had is you had a register that stored a random number, and that random number, which was constantly changing, was used to set the intensity of the LED bulb. And since that number was random and constantly changing, it made the candle appear to be moving, to appear to be flickering. And my client was infringing that patent. They had copied it exactly. And my job was, well, how the heck do I get around that? Well, a critical component of all of the claims was a register and a pseudo-random number generator. So the way I designed around that claim is I went to the client and I said, can you take a video of an actual candle and measure the light intensity of the candle under different conditions? Candle in the wind, candle in the rain, candle in the snow, candle in the this, candle in the that. And now take those intensities that you measured and store them in a series of registers, and have the LED be lit by those registers that are now moving in a random pattern. So now the contents of the register are not a pseudo-random number, but actually measured light intensities from a real candle. And that's how we got around the claims of that LED patent, was by, instead of using a pseudo-random number generator and a register, we basically directly measured light intensities and stored them in a register, so we could tell the client or the person that was suing us for infringement that we're not violating your patent because we do not use a pseudo-random number generator and a register. So, you know, again, design around, there's a lot more to design arounds than what I'm covering. Again, any one of these topics could literally take hours. So now I'm going to cover some online patent resources, enough to make you dangerous. The first resource I've already covered, Google Patents. Great resource. It allows you to find prior art. You know, it allows you to look at the drawings. It allows you to download the PDF. Incredible resource. Some other resources that, besides Google Patents, which are important, for example, are the actual United States Patent Database. This database should match Google Patents, but it also gives you some advanced searching that may not be available on Google Patents. For example, you can search applications, you can search patents. It's based on a Boolean search. So for example, if I wanted to find every single patent that included the inventor name Villamor, I would do a Boolean search, IN/Villamor, and you can see here IN is inventor name. And I can do inventor name Villamor and AQUA Ponics, AQUA Ponics, and aquaponics. And I'm going to copy the search because I know I don't have any patents yet that I know of. But you can see it returned 0 results, okay, in the patent database. Now there's also the patent application database, and you can do the same types of Boolean searches. And now if I search this, I should be able to locate my solar greenhouse patent, which I did. Now the advantage of the USPTO database, it does give you a little bit more flexibility with respect to searching for various things, you know, all these possible fields that you can search. So it does give you some advantages. There's also what's called the public pair site. When applications get published, they enter the public domain as far as published applications, and they become searchable by anybody. So for example, Public Pair is a resource that lets you see the status of applications that are pending. And I'm going to search my own application because I don't want to mess with other people's stuff. But you can see here that it gives you several, you got to enter that CAPTCHA code, and this is available to the public. It lets you search by various things: application number, patent number, PCT number, which is an international type of application, publication number, design registration number. So for example, since mine is not a patent, and let's see, I may have diverged from mine. Copy. Let's say I wanted to search for mine. Let's see here. If I search on application number, you have to be careful to get rid of the forward slashes. But if I search on that, let's see, patent application number, and for some reason it did not like that. Oh yeah, I'm sorry. I was searching, that was the publication number, not the serial number. There's a difference between the serial number and the publication number, and maybe this is a good time to show that. 3428, it wants another CAPTCHA. And here it is. Here's my pending application. And if we go back to my application, there's a couple of numbers. There's the publication number, which you can search on. And there's also the application number, which you can search on. And you got to make sure you put the right number in the right field, or you won't get the right patent. Let me kill this one. So now this is the patent, this is my case, and it shows everything that's happened in my case. And you can see when I, initial examination, all the things that have occurred in this case. You can access the published documents. You can see who the patent attorney is. You can see if it's been assigned to anybody. And you can see the application data for this case. It was filed on 2/27/15. It doesn't show the priority date, but it says that a non-final office action was mailed. That's an action from the patent examiner. So this is an ongoing case that's live. It's my case. And that covers the online patent resources. Now, one last thing to mention is their, patent search. There's pretty much all the databases of the world are now searchable. So like if you want to search for European patents, there's a facility for searching for all patents that are in Europe. There's a Japan, JP patent search, Japan Patent Office. So all the patent offices are now publishing their applications online. All of it is prior art. You can have a Japanese case cited against a US case, or a US case cited against a Japanese case. So that pretty much covers everything we're going to cover. If there's any questions now, I'd be glad to answer them. Of course, I did want to, hit a plug about my own website. My website is villamars.com, and there's a contact form through here. There's also an article section here, and here's an article that I posted that has to do with maximizing intellectual property portfolios. I call it Lean IPR. And this is a lecture that is available online, and I can also give to specific clients as needed. And the other thing I wanted to cover is sort of, how are companies going to survive? And let me find this. Here we go. I call this the big picture. It's a concept called OU812. And really, it's how are startups going to survive over the next 100 years? And the way they're going to survive is by forming these tiger teams around technology, where somebody like myself, like right now, for example, there may be lots of little aquaponics startups all competing with each other. and they're all fighting for the same amount of money that, there's a limited amount of money available. The concept that I'm going to try to implement in Finland this next trip in December at an incubator is to form these tiger teams. So for example, we might have an aquaponics tiger team where I come in as a patent attorney and we file patents for all the technologies that are related to the people that belong to the team. So we very quickly generate a gigantic patent portfolio covering, in this case, aquaponics products and services. And then we take that patent portfolio and we either sell it or license it to corporations. Now, the nice advantage of this OU 812 concept is also that once you have these tiger teams formed, you can also sell these teams as companies to corporations, or you can hire out these teams for product development, wherein we deliver, a patent portfolio and a suite of products based on a specification that comes over from a corporation. And this really is a win-win for the startups, universities, small inventors, and the corporations. In fact, the patent laws have gotten so pro-corporate that it's very difficult now for small companies really to be able to afford to protect their technologies. What I do to try to help in that respect is I teach people what I know, just like I'm doing right now, in order to minimize my time, because I'm the most expensive component in the patenting process. And by minimizing my time, I can make startups become very efficient in getting their patent portfolios patented. So that is pretty much it for me. I'm going to turn it back over to Damien. You still there?
Of course I am. Man, it's a great presentation, man. A lot of good information. Definitely appreciate you being willing to do this for us. I know there's a lot of people out there that had a lot of questions, and I think you answered just about all of them. So anybody that I don't see any active questions anymore on the on the chat screen. So if anybody else has any questions after this, of course they can go to your website and contact you through there. I did want to once again, real quick, thank our sponsors there, which I think everybody can see from their, Michael Neal 360 Training, and of course my company, Beams Consulting. Man, I think we're done. You did a great job. So, and for anybody that didn't get to see the whole thing, this should be completed and actively posted on YouTube probably within the next 30 minutes or so once it gets finished doing its thing. So thanks again for joining us this evening. If you don't have anything else to add, Carlos, I think we're done.
That sounds good. I will end the broadcast right now. And thanks a lot, Damien, for setting this up. I really appreciate it. And let's stay in touch.
Absolutely.
Carlos out.